IP, IP,
IP,
IP, IP,
IP,
IP, IP. Welcome to IP series, home to all things IP related, where I give you the stories, tips, and implications to business and creative decision concerning your intangible assets with real life case study. I am your host, Rita Anri Chinda. Subscribe and turn on your notification so you don't miss an episode. Cheers, guys. So for episode 106, I will be talking about intellectual property myth. So first off, what is intellectual property? Intellectual property is a creation or invention of the mind. The mind in this question would be human intellect, while the creation and invention would be the output of that human intellect that must be commercialized. They also get to enjoy legal backing and protection depending on the jurisdiction, that the work was created. How the work was created will determine who owns it and who can also commercialize it at the end of the day. So what are the types of intellectual property rights that exist in Nigeria, and why is intellectual property important to businesses and entrepreneurs? So intellectual property has different types, and they all have laws that grant the creators or inventors some sort of right. However, for the purpose of our conversation on intellectual property myths, we need to understand how important intellectual property is for businesses and entrepreneurs. Number one on my list is that it gives them the opportunity to earn recognition, to be recognized, and also to get financial reward for their creation and invention. What do I mean by this? Now, if you invent a product, or you solve a problem, or you improve on something that was already existing, for instance, the way we used to research, we still use Google, but now you have AI related tools. Don't misquote me, guys. Or let's use cars. We had manuals, and now we have automatic, and now we are doing self-driving cars. You get my drift? Yeah. This way you be able to prevent other people from copying your invention and also get to benefit from your invention. Secondly, intellectual property helps you distinguish your product or services from other people's own, basically. I mean, it's a no-brainer at this point. So if you have like a unique name, a distinctive name, a coinful name, a fanciful name, or logo, slogan, color, a bit non-traditional, but yeah, I mean, have you guys seen what Barbie is doing in terms of marketing and PR? Like, everyone is going crazy. Hi Barbie, hi Ken. I mean, the pink, all shades of pink. Everyone is going crazy with the color pink right now. And I think there's like a case. Yeah, I did see that on, I think it was on Twitter. I saw it first on Twitter, and then I saw it on Instagram. Someone, talked about it. The company that owns the Barbie merchandise, Mattel, is currently suing one of the big brands for wanting to register a similar name. I think it's Barbie, but spelled not as Barbie. You get. So they are opposing the registration. Kind of like, I mean, I think I was talking about this with someone else as well. But one thing you need to know when you're talking about distinguishing your product is that you get to build loyalty, customer loyalty, you gain reputation for your business. I mean, Barbie is pulling in the numbers with merch, with everything. I mean, they are utilizing the challenges, TikTok challenges, the color pink at the moment, a lot of merch deals, Aldo, Primark, you name it, guys. That's one of the benefits of intellectual property. I mean, let's say in the next 5 years, which other movie we want to attempt like a pink team marketing PR? No one. And Margie is doing a whole lot on the red carpet and on the tours. Have you guys seen her outfit? Damn it. Or like my boyfriend would say, damn it. Anyways, thirdly, intellectual property helps you prevent other people from stealing or copying your ideas. I think I've gotten a few of those conversations within the Nigerian IP space or creative or inventive space. There's always one social media call out or the other. This person stole my song, he stole my design, he stole my invention, he copied my. Your ideas cannot be protected. Let's get that one thing straight. You cannot protect an idea unless we see it in a tangible format, in form of a name, a logo, a product, something. You get. Um, you have to be able to maintain that information or product that gives you an edge in the market. For instance, Coca-Cola, I think, is like the most told IP story ever when you're talking about trade secret. You also need to protect your business from any form of unauthorized use. Make sure that someone gets a written um, consent, permission, and authorization. By doing that, you get to attract the right investors, the right partners, the right customers, the right collaborators who value your intellectual property assets and respect your intellectual property rights. Now, you see that IP is not just a legal concept. It's a strategic tool for business and entrepreneurs who want to succeed in the global market. And if you want to learn more about intellectual property, please listen to my last 105 episodes. I mean, I've talked about every type of intellectual property, you know. But then, copyright, as we know, will protect um, literary artistic works, sound recording, audio visuals, um, broadcasts, as long as it has it's original. You've put in some sort of effort. It doesn't matter. It doesn't really matter the quality. Trademark is for names, words, slogans. Industrial designs for aesthetic features or visual appearance, or the combination of lines and colors of your product. Patents, if you're improving on your invention is improving on something or solving a problem in the society. Trade secret basically protects confidential information. For instance, your secret recipe, business formula, all those kind of things. And plant varieties for distinct plants, seeds, trees, vines, all of the things. Then you have geographical indication, which businesses should not really concern themselves, but it's also a type of intellectual property that builds on the unique characteristics of a product from a particular region. So yeah, I think we've talked about the types of IP, like a very crash course on that, and also why IP is important for businesses. Now let's delve into the myths itself. Yeah. So number one on my list for um, intellectual property myths is businesses automatically own all intellectual property created by employees, contractors, and I dare say interns. Do you agree with me that businesses own all the business, your employer, your contractor basically owns all your intellectual property? I would say it depends on the contract you signed. If you sign a contract, then whatever the contract states there is final and binding. For instance, if a contract states that whatever work you created in the course of being employed or being a contractor or being an intern belongs to the person that employed you to do XYZ, I think that's final. However, if it says or states that any work you create while you're within the premises of the company, using the company's material, belongs to the company. However, anything you do or create outside the purview of your work or your employment provision belongs to you. So you now have to ask yourself, so let's say I work 9 to 5. If from 6 p.m. I start working on my personal project that belongs to me, as long as I'm not using the company's laptop or internet or whatever it is, now that contract is specific. In the event of no contract, now it depends on the type of intellectual property. Is it copyright? Is it a trademark? Is it an industrial design you created or a design right? Or is it patent? Or were you part of a technical working group working on a secret project for the company? You know, what measures have the company taken to protect or assert their authority, stating that they own that thing in question? Um, for trade secret or confidential information, whatever it is, I think the Samsung case of an employee disclosing certain confidential information on ChatGPT comes to mind. I think I've talked about it in some of the events I've been opportune to speak at or been invited to speak at. In that instance, now, this is not going to focus on ownership, but rather what the company had done to make sure that that information had not been disclosed. So, um, you know, how do you then avoid this kind of myth? Use a written agreement basically that specifies who owns the intellectual property right and how they can be transferred or licensed. And another case that comes to mind is the please call me back case. I enjoy talking about that case when I'm talking about this kind of scenario for employee. um the guy in question had, I've talked about it in my podcast. Please check, just listen to my podcast basically, or just type hashtag IP series on Twitter, and or please call me back hashtag IP series. Fuck. Oh my god. Just type hashtag IP series or please call me back. You're going to see my review about the case in question, and I apologize for the you know. But yeah, so that's about it for myth number one. Myth number two. Why am I laughing? I don't know, guys. But myth number two is trade secrets are protected by legal recognition. Hmm. So you know that um trade secret, like I previously stated, it's a confidential information that the owner must take precaution or put in measures to make sure that that secret is protected so that it doesn't lead to any kind of loss of competitive advantage. Because the more effort you put into protecting your secret, you're able to protect it from any theft or unauthorized use or losing your power in the market. Um, what are the requirements? Use give like a secret password or use encryptions or limit the number of persons that can have access to the information to protect your trade secrets, such as putting in a confidentiality agreement, security policy, employee training on intellectual property and trade secrets, and also breach of confidentiality. Let me just have the basic. And also in this era where a lot of people are experimenting with artificial intelligent tools, you need to make sure that your company is compliant. I think there is a post I saw this evening, trying to get to it on my phone. I had to screenshot it and share it on my WhatsApp status. Sometimes I share a lot of informations or posts I don't talk about them. So it goes like this. It says Chat GPT now investigated by the Federal Trade Commission for AI training data. So there's a lot of complications in that you need to take into consideration, such as data protection, data privacy, what are the laws within your territory, just to make sure that you're not going against any regulation or policy out there. And I think that's it for myth number 2. Myth number 3. Let's see. So myth number 3 would be intellectual property protection is too expensive and complicated. So sometimes when I get consultation requests and you give a charge, clients sometimes complain that it's too expensive. But trust me, it's going to cost you more if you do not protect your intangibles as soon as possible or at the earliest that you can. Because when someone infringes, so for instance, someone infringes on your copyright and trade secret grants you automatic protection. Now, under the Nigerian copyright law, the law states that a copyright owner that owns an eligible work, such as, books, songs, films, broadcasts, etc., may register. Then it goes further to give reasons why they should do that. In the event of a dispute, you can go back to the Nigerian Copyright Commission and request for a certified true copy (CTC) to use for documentation purpose in the course of your dispute, just to show that okay, you are the original author of that work. Now, for trademark requires that you register your trademark as long as it's capable of distinguishing or is distinctive enough. Now, if you cannot wait for, do a letter to the trademark registrar requesting that they give you their opinion as to whether your mark in question is distinctive or meets section 9 and 10, and you just go ahead to do the search and begin your registration. I didn't say register, I said begin your application to register to trademark your work. Doing that gives you some sort of leverage and edge. However, in the event where you do not register, you get to enjoy a limited form of intellectual property protection for your trademark, where you can sue for passing off and not infringement. Whereas for industrial design, if you do not register your design within 6 months, you have like a 6 months grace period under the law. Patent requires non-disclosure. You don't do any publication stating that, oh, I'm about to do XYZ that will solve this. Nada, we don't want to hear that. Do it in peace. Register your work and protect yourself. Those are the benefits of registry. So if you're saying, oh, someone gives you a charge for any of this intellectual property, and it's too expensive, can't afford it, it's not in my... Dude, you're not doing yourself any good. So the benefits of securing your intellectual property right for your invention and creation is that you're able to enforce your rights against any alleged infringer or potential infringer or unauthorized use, not social media call out this time, For instance, in the case of a startup that failed to patent their technology, they can lose the market share to copycats. How can you avoid this? Retain the services of an intellectual property lawyer or a copyright lawyer, a patent lawyer, a trademark lawyer, or an industrial design lawyer, or just retain an intellectual property lawyer just to save you cost. You can use IP management tools to track your products, your works, and then take advantage of any government incentive or program, depending on your jurisdiction. I know during the pandemic, when we're in the lockdown, the patent registry, introduced the utility patent registration model for inventions that needed to go into the market ASAP. So, also, I know the Startup Act has some sort of incentive for startups. There's also like a collaboration between the Startup Council, I think, and intellectual property offices within Nigeria. I don't know how that's going, but it's provisions that was made in the law, and then the Business Facilitation Miscellaneous Act as well. Check that out. But yeah, that's about it for myth number 3. Number 4. Intellectual property infringement is not a big deal and nobody will notice or care. Who tell you? Have you seen the rate at which people are tweeting? And now we are threading, we are seeing threads, we're doing TikTok videos or I think gone are the days of Instagram Live and Facebook. I mean, the easiest way not to get anybody attention about any kind of infringement is it used to be Clubhouse at some point, and I mean Clubhouse is less popular than it was. I don't know what really happened, but now there's a lot of threads being sued, Twitter posts, rooms on Twitter. What's that called again? I think it's wait though. It's been a while. I let's see. Spaces. Yeah, I just had to go back to my Twitter just to verify what is being called right now. Consequences of violating someone's intellectual property rights. You can be sued. Injunctions can be granted by a court. You can cause damage to someone's business. Can also be fined. You know, this is not about exploring the easiest way to resolve the dispute. I mean, there's a need for sensitization and education, and educating the general public basically on the consequences of violating someone's intellectual property. You can how can this backfire or harm your business? Um, in an instance where someone sues you for a huge sum of money for you for the unauthorized use of their work. One, the person that is suing you is hoping that he ends up winning and he gets the damages that he has asked for. So I think there's this case. There's this case I'm supposed to review. Yeah. So the applicant in question asked for 10 million, but all he got was 3 million. People are like, that's too small. I mean, at the end of the day, it's how your counsel was able to persuade the judge to see things in your own view, when granting your prayers at the end of the day. So, tips to avoid this kind of myths, where the myth says intellectual property infringement is not a big deal. It is a big deal. Nobody would notice. People will care. I mean, in this era of social media, people will definitely talk about it. It's actually going to trend. Like the last post I just made about the translator. You guys should please read it. I'm also going to do the podcast version as well. Yeah, people notice, people care. I mean, sometimes it's good when IP owners go to court because we have a precedent to rely on. For instance, the NFT meta backing case, we have a precedent. So anyone delving into the metaverse knows that, okay, I need to have the physical right as much as the virtual right. I hope you guys didn't hear that, but yeah, fair use or fair dealing will not save you at the end of the day. Make sure that you do your due diligence. Look out for public domain exception. Public domain will come in when a work term of duration for protection has expired, and then it goes into the public domain for any person to be able to commercialize it. Make sure you're getting your licenses, you're obtaining your written licenses, whether it's exclusive or non-exclusive licenses, to be able to use an intellectual property. And that's about it for myth number 4. Myth number 5. What's myth number 5 going to be on? Let's see. Okay, so I've talked about this. Yeah, if you don't have a copyright symbol, anybody can use it. How true is that? And is it true? No. I mean, copyright, amongst what intellectual property, like I earlier stated, that it gives you automatic protection. So whether you use the C and the circle, or you put the copyright notice or not, you already enjoy protection. But how do you go ahead to, protect your copyrighted work from being infringed or being reproduced or distributed or communicated to the public or adapted or translated without your consent, permission, or authorization? So when you think about this myth, an example of how this myth can result in liability or damage to reputation is when you're being sued for XYZ amount for posting a copyrighted photograph. For instance, we had I think it's still there, where paparazzis are suing a lot of celebrities for reposting images of themselves. It raised a lot of issues. Now we are dealing with AI related content. Came across this case again, trying to get to it now. Yeah. So the post reads: AI Senate hearing on arts and music copyright protection. Universal Music Group VP of Legal Affairs and artist Carla Ortiz appeared before the Senate Judiciary Committee to argue against exploitative AI companies who stole private data and creative and copyrighted work to train and commercialize generative generative AI models for profit without consent and compensation from the original creators and owners. UMG and the music industry are gearing up for lawsuits against generative AI companies, which will come down the pipe before the year ends. Ms. Carla Ortiz is already part of a class action lawsuit that, in my opinion, that is at Meijin the artist. He's on Twitter. You guys can check him out. Review vicarious infringement will ultimately cripple and downgrade generative AI models due to their unjust appropriation and unethical theft of creative and private contributions from billions of unsuspecting and unconsenting users. Now he goes further to say, huge. AI just got roasted by the number one music label in the world, UMG, whose VP of Legal Affairs just said it would be hard to opt out if you don't know what's being opted in. And that is true, because I do recall a case where someone had opted in one of these AI related tools, posted his pictures, and he wanted to opt out and they refused. He sent a cease and desist letter accusing me of copyright infringement. I went ahead to sue him. I mean, it's insane. Then he goes further to say the statement echoes sentiments expressed by many artists over the past few months, and I agree. It's encouraging to see this logic being acknowledged by the top brass of the number one record label in the music industry, which represent major artists like Drake. I love Drake. The Weeknd, love him. Taylor Swift, yeah, shake it up. I'm gonna stop there. Yeah, so he said also huge. Federal rights of publicity and AI training data transparency was just proposed by UMG's VP legal counsel in the video above. So there's a video, I think it's an 11 minutes long video. So if you have the time, please check it out. To protect artists and creators from style and likeness appropriation. That falls under image rights basically. So in the US, right of publicity, image rights extensively researched and precedents out there. In Nigeria, not so much. I mean, I talked about the Banire case, which I felt would have been a good precedent, but the court had, a better view and better judgment about the case. But yeah, so how can you avoid this kind of myth where someone will tell you, oh, if there's no copyright symbol, you can use it? Nah, lie. Trust me, they are basically deceiving you. So, one, you need to respect the rights of original authors or creators. Know that, for instance, under Section 9 to 13 of the Copyright Act, it lists the exclusive rights or the bundle of exclusive rights and every eligible copyrighted work author enjoys, it as a literary, artistic work, musical work, audiovisual, broadcast, performance, and there's this conversation about economic right to earn and moral right to prevent third parties from derogative use of their work, modification, or defaming the character of the original content itself. Make sure you seek permission or get a license, give proper credit or citation. It's not disclaimer, this video does not belong to me, or this picture. At now, there's a lot of, everyone has an account at Esmeralda ASQ. Tag me, yes, acknowledge me, But yeah, that's about it for, I think it's myth number 5 right now. I kind of lost. I think it's myth number 5. So we're on to myth number 6, and that is intellectual property protection is perpetual. That's a lie. So all the types of intellectual property have like a term of duration. What that basically means is how long these inventions or creative works can be protected. So for the duration of the lifetime of the author, for copyright work, plus 70 years after the death of the author in question. So 70 years for literary work, 50 years for photographs. If it's an orphan work or anonymous work, I think it's 70 years as well. Yeah. Whereas trademark grants you so you have 7 years initial protection and then consecutively 7 years, subject to you paying your renewal fee or rate. Industrial design 5 years, subject to your renewal fee, consecutive 5 years, 5 years, so that's 15 years. Trademark can last you for as long as you can commercialize or monetize it. You don't need to basically wait on anyone to tell you, oh, after this 21 years or 7 you're done. No, you see a lot of I would say bigger brands that have lasted for years, like you're hearing 105 years. Guinea, patents 20 years, and that's not counting from the day of your application. Plant variety, should I even be mentioning this? I think I should. Yeah. Plant variety, let me not misquote. Anyways, but the basic thing is that once all of this has exceeded their term of duration, it all goes into the public domain. You also have for trademark whereby your distinctive name can become generic, and that one then leads it to it's no longer unique or distinctive. It's just there for anyone and everyone, and you're asking yourself, what did I do wrong? So from the moment you notice that your trademark is kind of lagging behind or entering the it's entering the consumer's mind like any other common word out there, that you need to rebrand. I can't remember the name of the brand that actually did this, but when it turned out that their brand was becoming like a very common word, they had to rebrand and change tactics on how to remain in a very positive way in the minds of the consumers. You can also extend your trademark with good strategy and constant use in commerce. But yeah, that's about it for myth number 6. But yeah, so far I've mentioned 6. If you have anyone that I may have missed out or you think I should include, please send me a DM and I might end up doing a newsletter for you guys. I'm nice like that. But yeah, that's about it for myth number 6. Myth number 7, international IP protection and international patent protection, like a world. So I get calls sometimes and like, oh, I'm around to do a worldwide protection. There's a time, I won't say a period. I got this request and I was like asking the person, please, can you kindly specify the jurisdiction you want to expand your registration and protection to? And I was like, I want a worldwide protection. Fam, the challenge is, one, it's gonna cost you more. We have the national, which is the Nigerian. You have the regional where you explore Aripo or WAPI, which Nigeria is not even signatory to any of this. So more money for you. Then you have the EU IPO, the US PTO, and other jurisdiction, or with the white um, platform that you can use to register your intellectual property, depending on the treaty in question, just to protect yourself. You can't be all over the world, so you need to now employ someone that would help you register. So intellectual property is territorial in nature. It's only the jurisdiction that you end up protecting or registering your work that you get to enjoy the legal backing of the law. However, like I said, there are regional registrations that can be explored and treaties that enforces priority for contracting state members. So you get to explore all of that. Sometimes even the use of IP management tools may not protect you in a cross-border related infringement, and because you don't really have someone on ground, or maybe that jurisdiction does not allow such things to be used, especially in view of data, getting data, accessing data, or information. How can this meet expose businesses to infringement or risk or missed opportunities? Basically, the case of Apple against Samsung over the Samsung patent, that's like a very good example. I was going to read the case, but it's kind of going to make our conversation a bit more longer. But just Google I know there's a period when Samsung and Apple were always fighting over the patent of the smartphones, all those conversations, utility patents, this one, that one. But then tips on how to avoid this kind of meetings: conduct a patent search or an IP search within that jurisdiction, file your application in key markets, also get professional advice on international IP strategies that you can explore. But maybe what I can do for my IP friends alternatively is to give you like examples of key international IP strategy. First, you need to know what an IP strategy is, and this is like a company's way or mode for managing and protecting its intangible assets within that particular jurisdiction. You need to have like an intellectual property checklist that provides a non-exhaustive list of questions and possible actions that can be considered throughout the company's commercialization life cycle. Remember that in the definition of IP I talked about, you commercializing your work. The checklist will be divided into 4 parts. You have the ideation stage, as when you're generating or developing your ideas. Production or service, IP protection in terms of registering or securing your assets, and then monetizing it through commercialization and getting into the market itself. So for stage 1, which is the ideation stage, and now I'm reading from a publication published by the World Intellectual Property Organization. So under the ideation stage, it says the commercial application: does this idea has commercial value? You need to now identify your intellectual property asset, capture those ideas, or your assets rather, confidential information. You're talking about trade secrets, restricted assets. You drop a non-disclosure agreement or non-disclosure clause or non-compete clause. Likelihood of intellectual property protection by exploring a multi-tiered IP protection, such as getting, say, a domain name or plant breeders' rights search, or a design right search, or patent search. When you're collaborating with third parties, how do you secure ownership or access to the IP created? Identify who your competitors are, and so that you don't fall or get into a situation where someone is accusing you of creating similar product, or that is a likelihood of confusion, or you're infringing on third party rights. Then the production service service development, into consider third party rights. Does the business have processes or procedures for addressing IP ownership consideration when collaborating with third parties? For instance, when you're marketing in an employment relationship, a research and development relationship, a licensing agreement, What is your IP strategy implementation? How do you take into account the overall business of the company? Does the business have technical or an IP review committee to decide on product or service development? Um, do you have like a freedom to operate search or a competitor analysis to identify any potential competing IP rights? Then IP protection, you need to have a good strategy. Then you're exploring like a multi-tiered protection. So you have a trademark for your name, logo, design right protection for the visual appearance of your product, improvements on an invention, patent, Then prioritize your IP protection. Which one should you consider first if you don't have the funds? You do recall that one of the myths said IP protection is expensive. Then monitor ownership, and then have like a good IP advice. Then have like now you get to the commercialization aspect where you consider either selling, licensing, assigning model for your business, how you can monitor your competition, branding, audit, IP policy, and education. And so that's about it for this particular myth, or myth number 7. Myth number 8, and I think I'm going to wrap up with this one, which is that all intellectual property uh, enjoy automatic protection. It's only copyright and trademark that grants you automatic protection from the moment your work is created. The others requires you to register your work. For unregistered trademark, you need to show consistent use within 3 to 5 years, depending on the jurisdiction. Then if it's official, then it probably is. If it sounds official, then it probably is. Beware of common scams that target IP owners, such as fake invoices, renewal notices, or domain name registration. I think I've been seeing a lot of publications about fake invoices and renewal notices regarding the US. I think Eric talks about that a lot. Seen it across my timeline. And this is because if you're not wary of all of this, you might end up losing money or compromising your intellectual property rights. Make sure that you always verify the source and legitimacy of any IP-related communication or reporting any suspicious or fraudulent activity to the authorities. For instance, if someone sends you, say, a document from the trademark registry or the patent registry, you need to verify that it's really from these registries. For instance, I had a colleague reach out to me one time to verify a registration. He thought it was a trademark registration, but upon our search, we found out that it was actually a patent registration that was done and not a trademark. So that means the client in question had lost money, and that is not good for business, So any IP notice you get, someone sends you a cease and desist alleging that you stole their work. Maybe you actually use somebody's work, but you're not sure who owns it, or when you were trying to verify the chain of title, you couldn't figure that part out. And you're like, these people don't catch me, they don't catch me, they don't catch me. You start panicking. Or maybe you know that you haven't renewed your trademark for this year, and someone sends you a notice. Oga, you suppose this is from the registry. Come and pay. If not, we are going to, and you rush, and all these scammers. So anytime you get all those kind of letters, invoices, make sure you reach out to your intellectual property lawyer that your firm has or your company has retained. And if you don't have like an IP department in your company till now, please start considering it. You may not be able to afford one or create one, but just have like a law firm or an independent intellectual property lawyer to help you verify all of these things so that you don't end up losing money at the end of the day. And that's about it for myth number 8. So in wrapping up, our key takeaways is retain an IP lawyer or retain a firm that will help you carry out due diligence, create IP strategies, help you monitor your work, verify official letters or emails that have been coming, help you not to commit infringement, yeah, properly advise you on intellectual property basically, and um, help you understand the importance of understanding and managing your intellectual property so that your business will thrive and our economy will also thrive as well. So I want to thank all my IP friends for listening to me. Thank you guys for always sticking by me. If you have questions, please share feedbacks with me. If you enjoyed this episode, please subscribe, rate, review us on any of your favorite podcast platform. You can also follow us on social media. We're at IPSeries_with_reader or IPSeriesInfo@gmail.com or at IPSeries1 on Twitter or at Esmeralda ESQ. That's my personal account, or just Google my full name. It's original. Then you see me, you can, like I said, follow us on social media. For more information about intellectual property, if you would like to consult as well, if you would like me to come speak or teach your company about intellectual property, I'm right here. Until next time, keep creating and keep innovating. Cheers, guys. Mwah. Lots of love.